Director James Comey and former Attorney General Loretta Lynch. Lastly, the committee is adopting these procedures to facilitate its ongoing investigation to determine whether to recommend articles of impeachment against the president. Second point I want to make is the objection that we've heard from several of the Republican members that this is not a real impeachment because the House has not voted to authorize the committee to conduct an impeachment inquiry. The committee's ongoing investigation to consider articles of impeachment, which is what we're doing, is fully consistent with the Constitution, House rules, and past precedent with regard to impeachment. First, as to the Constitution, Article 1, Section 2, Clause 5 grants the House the sole power of impeachment. It does not say anything about a particular procedure that the House or any committee of the House must follow. Second, there is no House rule requiring the House to take a full vote before a committee engages in an investigation to determine whether to recommend articles of impeachment. In fact, a rule like that would be inconsistent with House Rule 11, Clause 1B1, which states that, quote, each committee may conduct at any time such investigations and studies as it considers necessary or appropriate in the exercise of its responsibilities, close quote. Third, House precedent clearly demonstrates that the Judiciary Committee's jurisdiction includes consideration of articles of impeachment. The Judiciary Committee has conducted every impeachment investigation that has occurred in the House since 1900. Fourth, the Judiciary Committee has frequently conducted investigations to consider articles of impeachment without express authorization from the full House. Modern examples include impeachment investigations of Justice William O. Douglas in 1970, Judge Harry Claiborne in 1986, Judge Walter Nixon in 1989, IRS Commissioner John Koskinen 2016 under the last Republican majority. In fact, following the Legislative Reorganization Act of 1946, the majority of impeachment resolution investigations conducted in the House have occurred without, and let me repeat that, the majority of impeachment investigations conducted in the House have occurred without the full House specifically authorizing a, quote, impeachment inquiry. In light of this precedent, the committee and the House have made clear that the committee has full authority to conduct its current investigation for the purpose of determining whether to recommend articles of impeachment. In May, when the committee voted to recommend that Attorney General Barr be held in contempt, the report approved by the committee made clear that one of the purposes of its investigation was to determine, quote, whether any of the conduct described in the special counsel's report warrants the committee in taking any further steps under Congress Article 1 powers. That includes whether to approve articles of impeachment with respect to the president, close quote. In June, the full House voted to approve H.Res. 430, which affirms that this committee and all other committees have, quote, any and all necessary authority under Article 1 of the Constitution, close quote, to conduct their investigations. The accompanying report by the Rules Committee expressly states that this authority is intended to facilitate the Judiciary Committee's ongoing investigation, including its assessment of, quote, whether to recommend articles of impeachment with respect to the president, close quote. I myself have also noted on several occasions that articles of impeachment against the president have been introduced during the current Congress and are under consideration by the committee. I do not agree with the argument that the full House must authorize an impeachment investigation simply because the House did so for investigations of President Clinton and President Nixon. In fact, in the case of President Nixon, the House Judiciary Committee had already begun considering articles of impeachment and holding hearings for more than 6 months before the full House formally authorized an impeachment inquiry. As the members at the time noted on the House floor, the resolution passed by the House merely reaffirmed the committee's authority to conduct its already ongoing investigation. In the cases of both Presidents Nixon and Clinton, the House's authorizing resolutions served a specific purpose. They granted the committee additional investigative powers, such as the authority to issue subpoenas and conduct depositions. Under the House's current rules, the Judiciary Committee already has those investigative powers and all investigative powers necessary to conduct its work. We are conducting that investigation. We do not need a full House resolution to authorize it. It is authorized, and we are doing so. And I yield back the balance of my time.
Chairman.
Who else seeks recognition on the amendment? The gentleman, for what purpose is the gentleman from Wisconsin seek recognition?
Move to strike the last word.
The gentleman is recognized.
Chairman, let's get back to the amendment offered by the gentleman from Florida, Mr. Gates. What the amendment does is say only members and not staff can examine and cross-examine the witnesses that are brought before the committee. Now, I agree that the chairman has stated the precedents that have occurred in the past, but we are talking potentially about impeaching the President of the United States. And when we deal with something that is this serious and has only actually been seriously considered 3 times before in the nation's history, I think it is important that only the members who are elected and who are accountable for their actions here in Congress to their own constituents do the questioning. Not unelected staff who can go all over the place and not suffer any type of electoral problems because of what they say or what they do. This amendment is a question of accountability. It is a question of accountability of the 48 of us that are 38 of us who have been chosen to serve on this committee, knowing full well what the committee's jurisdiction is. I think that this committee owes it that only members in hearings like this, when witnesses come before us, question members. And the constituents in each of the districts that we represent can judge whether their member is acting responsibly and in the public interest or not. Not the unelected staff, which I don't think we should be doing when we're dealing with an impeachment that is as serious as one as the President of the United States. So let's be accountable. Let's adopt the amendment, and I yield back.
Anyone else seek recognition on this amendment? The gentleman, for what purpose does the gentleman from Georgia seek recognition?
Thank you, Mr. Chairman. Look, I think, all things aside, and I think we've talked about a lot of things, this is important because the confusion that is out there, the discussion has been in the press, everything has been talked about saying, and you even acknowledged in your opening statement that there's confusion out there about what this is. And if you look at any of the Hill papers or even across the country, there's been this discussion: are we in impeachment? We're not in impeachment. So I appreciate your reading this long list of discussions on when we've done this and when we've not done this. I would not use any judge or judicial impeachments in this because that's actually within our purview, doesn't need anything else. That's where it's supposed to be anyway. That's not new. So put judicial in here. It's really not it's nice to throw in, but it's not in the same vein. Also, you talked about procedures mattering. And I made this point at the very beginning. Nothing that we're doing today could not be done on any regular day. The problem that is coming up today is starting from last Friday on until we sell this, it was this discussion, also informal court filings, in which there have been, that a formal inquiry has started. And that means a whole different thing to anybody that's wanting to discuss this. Now, in this building, we discuss, and in this committee in particular, we will debate the commas and everything else. And that's what we should be doing. But the general public does not. The general public just sees the press release, they see the discussion, and they take it from there, and they believe something that is not actually happening. And it does matter. Words matter here, and how we deal with this. You talked about procedures and coming up into impeachment. Right here are 900 pages of procedures if we were actually in an impeachment inquiry. This is from the 74 and from the Clinton. 900 pages of procedure. So to say that procedure doesn't matter, or that these 3 procedures are actually determining, if we're looking into an inquiry. In fact, if you go back to 74, Peter Rodino actually determined that they wasn't in an impeachment inquiry, and that they actually went back to the House to gain more subpoena authority for that. If we want to be historical here, let's be historical. And I think that this is why it comes down to this issue of staff question. It comes down to the issue that we've talked about all along here. In fact, you brought up the June vote, and the June vote was interesting because it actually had to go back and have that June vote because there was questions from the court about the actual authority to do what we were doing. So I think that's where it's becoming an interesting issue here, is that we're not addressing the head-on conclusion here. And the head-on conclusion is that you can't have this discussion in 2 veins because, again, it's not what we're discussing here, and we can all, maybe agree on one point or the other point from a very fine legal term, but when it's out in the general public, when it is out there for the headline of a news or a media where they have to condense down to 600 or 800 words what is happening here, and they do so really not with 800 words, they do it with a headline. And whether it's, whatever broadcast it is, they do it with a tag across the bottom on TV, they do it with a headline on the in their news articles or their paper or their blogs or wherever they put it, is they put out, from this own committee saying we're in a formal impeachment inquiry. that connotates something completely different and triggers a completely different response from this committee, a completely different overall, and we can agree or disagree on why we're here, but at least let's get the terms straight. Let's at least acknowledge why it matters. You may want to impeach this president all day long and twice on Sunday. Fine, do it the right way. But that's not what's happening here. We want to have it as a subtle backing saying, here's what we're doing, we're inching toward it, but we're making sure that everybody understands that we're trying to hold the president accountable, but we can't get there because we know we don't have 218 votes on the floor. Nobody has denied that you're not trying to find a reason to impeach the president. Nobody on our side or anyone else. You've been talking about it for a long time. We get that. But don't hide regulations, or not regulations, but rules of this committee, which you could have done at any point, at any time, on any hearing. These are already part of our rules. So, from our side who, discuss this, say this, is something going forward, we got to make sure that this is wrong. No, and from your side, let's deal in the reality. We want to have as many of these hearings as you want to have them. Acknowledge that you're still looking for your answer. You two said it best. I still haven't found what I'm looking for. And that's what we're doing, and that's okay. But at least acknowledge that there is a reason why these are not formal impeachment inquiries. There's a reason why the House has set this up. And for you who've served on it and spoke very eloquently, by the way, I've read all of your most of your comments from the late 90s and the Clinton impeachment. You agree with me. It's sort of interesting. We have similar conversations here that you would have agreed with me now in the previous comments that are in the record from the Clinton impeachment. So I think as we move forward, this is why we're making a big deal of this. This is not, we just need to make sure that you can done all this that you wanted to in a regular setting. But the problem is you're wanting it packaged as if it's something it's not. That's why this concern is here. That's why we'll continue to speak out against it, and I yield back.
Mr. Chairman.
The gentleman yields back. Gentleman from Louisiana. For what purpose does the gentleman seek recognition?
Wanted to just ask maybe it's a point of parliamentary inquiry regarding your opposition to the amendment, and it's a serious question, Mr. Chairman. I just wonder if you'd answer. You're opposing members doing the additional hour of questioning, and I'm wondering. I don't mean to be flippant. Are we concerned about the time commitment or the competency of members of the committee and why they would not be able to fulfill that extra hour?
It's not a parliamentary inquiry. The reason I'm smiling is that it reminds me of a question I asked a senior member of the State Assembly when I was a freshman, and I've always regretted asking. But that's a separate...
Well, I don't regret asking this one. Look,
let me just say, the reason for staff is not... Remember, this is after the 5-minute rule. And it's very clear, and that's why in various inquiries, when Democrats are in the majority, when Republicans were in the majority, and I listed some of those inquiries, not all of them, it has often been done that staff or staff counsel can ask questions because the 5-minute rule can be disjointed. And we will observe the 5-minute rule, but after that, we may elect to have counsel for the majority and minority question up to half an hour so you can pursue questions with the witness. And it's been observed many times that is a very effective, I won't say more effective, but it's an effective way of getting at the truth and at eliciting facts. And that's why we want to do it, and that's why others have done it.
well, Mr. Chairman, but it's within the rules. It's within your authority.
The gentleman still has recognition.
Well, I just want to suggest that we could...
strike the last word?
Strike the last word, yes, sir.
Gentleman's recognized.
We could allow for additional time for members to do more questions. If the 5-minute rule is unruly, let's allow for more time. As has been stated so eloquently by my colleagues, this is a big deal. You're talking about impeaching a president. I'm sure that we can find the time in our schedules, and I'm quite confident in the competence of every member of this committee. Most of us are attorneys. We've all questioned witnesses before. This is well within our scope of competence, and the reason we're on this committee is to perform important duties like this one. We do not need to delegate this to staff. We can handle it, Mr. Chairman. Why are we not allowed to do it? I yield to Mr. Collins.
Thank you, and I appreciate the gentleman. What's interesting here is the exact same rule allows for what you just said.
Right.
The exact same rule allows members to have that time and to extend that time, and if the concern is time, fine. Then we can do that. In fact, that's what we will probably end up doing. But the same rule that we're using here to allow staff to have that extra 30 minutes is the same rule that can be allowed for us to have the same time. I'll yield back to Ms. Johnson to Mr.
Yield to Mr. Biggs.
Thank you for yielding to me. I just want to point out, in other hearings that are momentous like this, you'll see an extension of time to 10 minutes. We could do that. We could change the rule. This is a self-governing body. We can change that rule. But moreover, we could allow for multiple rounds. We could allow for multiple rounds for members to ask the questions. We don't have to designate the staff. We don't have to remove the responsibility that each one of us took upon us when we ran for office and were elected and were appointed to this important committee, facing an important historical decision, whether we overturn an election. We don't have to settle on, say, oh, okay, we're going to just give it to the staff. We can do multiple rounds. We can extend the time. We can do that, Mr. Chairman. I think we have perfectly capable people on both sides of the aisle. If the object is to really get to the bottom of this, to get to truth, so we can make an informed decision, the people that are making that decision ought to be allowed to ask those questions. And with that, I yield back to Mr. Johnson.
And I would just suggest this is not unprecedented to allow members additional time. We were talking back here on the bench about our memory of the Benghazi hearing, for example, where I think all members got 3 rounds of questions, perhaps I think it was as long as 10 minutes each. This is certainly as important as a Benghazi hearing. Why would we not be allowed to do that? I would argue we have the most competent committee in Congress. These are attorneys, everybody on this dais. We should have the ability to do that. Yield to Mr. Gomer.
I don't want to sound like Pollyanna here, but I take it as a great compliment that they would rather have Republican staff members ask the questions than any of us ask the additional questions. So I yield back.
All right, Ms. Collins.
Mr. Johnson, let's clarify something. House rules is 5 minutes. So we get the 5-minute rule is 5 minutes. Now, we can go multiple rounds, and then we can do that. But what we're asking here is in the same rule that we can go outside of that 5 minutes by doing this with staff and then also with members. And I think that's, again, the very same rule is what we're dealing with here as we go forward. So with that, I yield back to you.
I yield back, Mr. Chairman.
Move to strike last word. Thank you, Mr. Chairman. I was struck first of all, I think that the gentleman from Florida's amendment is rational, it is purposeful, it is something we should do. I think it furthers the cause of getting at the truth here and allowing the American people to see what their representatives are doing. This would be a momentous hearing. Let's just be honest. This will be a momentous investigation if it becomes such. And I find the inconsistency here trying to move to the staff is consistent somehow, ironically, with the inconsistencies that I heard in the our august chairman's opening statement. And then the response that he gave to the gentleman from Florida. So he used this notion that, and he provided many instances where there had been no resolution by the House in toto prior to the Judiciary Committee conducting an investigation. But he could never list an impeachment proceeding against the President of the United States. He listed a bunch of judges. Now remember, judges are appointed by Senate. For practical purposes, they have devolved into this lifetime appointment, even though the Constitution tells it a term of good behavior. They're unelected. They don't face the people. They've not been elected by the people. Instead, and the reason that this is so critical, and the precedent has been it goes to the House first, is because a president is elected, subject to a vote by the people, will be responding to people within a maximum of 4 years, depending on when the impeachment gets. That's important. That's the distinction. That is why you typically would take this to the House floor first. And right now, you have almost 60% of Americans oppose impeachment. That same Monmouth University study cited by my colleague from Florida also indicates that a majority of the country opposes the opening of an impeachment inquiry by this committee. The Speaker of the House, the Senate Minority Leader have issued conflicting statements, but they seem to indicate opposition to an impeachment. Less than 2 months ago, the entire body voted on an impeachment resolution, and it was tabled. It failed by a vote of 332 to 95. I mean, think about that, 332 to 95. 137 Democrats, a majority of the Democrat conference, voted against that bill. There are strange articles that are coming out in opinion pieces. One by the Washington Post, wondering what is driving the chairman, and the title of that article on July 29th was, "Could concerns about a primary challenge be behind Nadler's impeachment posturing?" I don't know if that's true or not. I'm just citing an article that came from the Washington Post. That is something to be considered. I mean, something interesting, don't you think?
Mr. Chairman.
There's nothing shameful about it.
Mr. Chairman, I would like to make a point of order.
Gentlelady will state a point of order.
That the committee rules prohibit questioning the motives of other members.
I'm not quite.
I would hope, and I never do that, and I would hope that members will be conscious of the rule, and I thank the gentleman.
Thank you.
Members will be mindful of committee rules.
Thank you for reminding me of that. I was not unaware of it. That is why I said, look, I'm reading the title of an article that came out. That's all. But I will talk about inconsistencies yet again. When the chairman cites to the court that any such materials, meaning grand jury materials, would be stored in a secure location with access restricted to committee members, HPSI, so Judiciary and HPSI only, that is inconsistent with Rule 11 of the House. And he cited Rule 11 just moments ago, so I know he's familiar with it. Those inconsistencies must be cleared up. And with that, Mr. Chairman, I support the Gates Amendment. I think it's critical. I think it's important, and I yield.
All in favor, say aye. Aye. Opposed, no? No. The amendment.
I didn't mean to report.
Mr. Chairman? Gentleman, what purpose is the gentleman from Colorado seek recognition?
I have an amendment at the desk.
The gentleman has an amendment at the desk. Goes to the report. Gentlelady reserves the point of order.
Amendment offered by Mr. Buck of Colorado to a resolution for investigative procedures offered by Chairman Gerald Nadler. Beginning on page 1, line 11, strike using his official powers to thwart or attempt to thwart the special counsel's investigation and replace with allegedly attempting to obstruct justice under 18 U.S.C. 1503, 1504, 1512b3, and 1512c2. But as those allegations, the Office of Special Counsel did not draw ultimate conclusions about the President's conduct, and furthermore acknowledged that the Office of Special Counsel did not conclude that the President committed a crime, and nevertheless.
The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, most of the members of this committee are lawyers or were previously...
The gentleman will suspend. The gentlelady withdraws, will not insist on a point of order. The gentleman will proceed.
Thank you. Most of the members of this committee are lawyers or were previously in law enforcement. Because of that, we should act like lawyers. Because we're the Judiciary Committee, we should seek justice. And because we represent the American people, we should be fair. For these reasons, our committee has an obligation to use legal terms correctly. My amendment clarifies the language in the second whereas clause of the resolution to ensure it uses proper legal terminology, reflects the constitutional presumption of innocence, and accurately characterizes the Mueller report. Why is my amendment necessary? This resolution fails to convey Special Counsel Mueller's conclusions. The chairman's resolution makes an error by using words that are not in fact a crime. Where in the United States Code does it say that thwarting is a crime? What is thwarting? If anything, the correct and proper terms would be obstruction and attempted obstruction. We are the Judiciary Committee and we should use the correct terminology. In terms of those crimes, this resolution suggests the report found the president improperly used his official powers. Mr. Mueller's report, however, makes clear that there were no such findings. The Mueller report said the Office of Special Counsel, quote, did not draw ultimate conclusions, end quote, and, quote, did not conclude that the president committed a crime, end quote. By falsely suggesting a criminal conclusion was reached, this resolution fails to provide the president with the presumption of innocence guaranteed by the Constitution. I believe it is important that this resolution stay true to the law, the Constitution, and the findings of the Mueller report. It does not. My amendment corrects for these oversights and inadequacies. In summary, my amendment deletes references to thwarting and attempting to thwart, as these simply are not legal terms, replacing these terms with the correct legal terminology. It identifies the exhaustive list of obstruction statutes that the special counsel considered. And finally, it accurately characterizes the report's conclusions about obstruction, quoting directly from the Mueller report, which is consistent with what Mr. Mueller has said publicly at a press conference and before the House Permanent Select Committee on Intelligence. This committee should seek the truth in all that we do. My amendment is a necessary amendment to ensure this resolution reflects the truth of the information we have reviewed. I would urge the committee to adopt my amendment. And I yield to my friend from Texas.
I was just wanting to ask a question. You've obviously looked at this a great deal. So if the president thwarts Iran, thwarts North Korea, that would not be a crime?
I'm unaware of any crime using the term thwart. I'm not even aware of what thwart is. I'm aware of a wart, which is what this resolution contains many of, but I am unaware of the term thwart.
So it's apparently not a high crime or misdemeanor to be a thwarter?
No.
All right, thank you for clarifying.
I yield back, Mr. Chairman.
The gentleman yields back. I recognize myself in opposition to the amendment. I will simply make 2 points. Number one, an impeachable offense does not have to be a crime. And a crime, by the way, may not be an impeachable offense. Those are two separate matters. And I'll repeat, an impeachable offense, an offense for which someone should be impeached, need not be a crime. Second point I want to make is that we believe that the description found in the resolution accurately and adequately portrays the findings of the special counsel's report, and therefore I oppose the amendment. Is there any further? I yield back. Is there any further discussion? Gentleman from Minnesota.
Thank you, Mr. Chairman. And before I weigh in on the Buck amendment, I want to apologize because I was not trying to ascribe any motivation when I was quoting that. I want you to understand that tonight. I apologize if it was misconstrued and if I misspoke. But I support the Buck amendment. I think it is important to have clarity here, and I think that Mr. Buck is right on the money here. I also want to point out another issue with the resolution on page 4, line 108. It says information obtained pertaining to the committee's investigation shall be deemed received in executive session. Now, typically under House Rule 11, Clause 2G1 states that all committee meetings and thus all evidence taken shall be open unless the committee itself has voted in open session that the meeting will be in executive session. Effectively, what's happening then by deeming all information obtained to be received in executive session, effectively, not only are we delegating interviewing to and questioning to our staff, we're taking away a lot of the committee's right to vote on the pieces of information, whether they should be concealed from the public. This clause instead allows all information to be concealed in this amorphous quasi-impeachment process that we are engaged in. The rules say you can only go into executive session if disclosure of the material would, 1, endanger national security, 2, compromise law enforcement, defame or incriminate someone, or 4, violate a law of the rule or rule of the House. This clause is not limited, for instance, to grand jury information. This clause would conceal all information. And I'm referring to the clause on page 4, line 108. It would conceal all information from the public without a vote from the committee, without us taking that vote in committee on each piece of evidence. So my staff has worked with CRS, and CRS could not identify any instance in the published precedents of the House where this committee has taken away the members of the committee's right to vote on whether to go into executive session. So this becomes a bit of a problem. Taking away the members' right to vote on whether to accept a particular piece of information in executive session appears to violate Rule 11, Clause 2G1. Certainly, it is at least not in the spirit of the rule, which is meant to keep all committee records public and available unless a specific exception is met. So this is problematic. You prevent the committee members from viewing the committee's records. And we're voting today to actually prevent the public from having access to committee records as well without any of the particular sections and exceptions. And so with that, I'm going to yield to the gentleman from Colorado, Mr. Buck.
I thank my friend from Arizona for yielding. Mr. Chairman, I am stunned that you don't agree with me on this amendment. And saddened also. I just want to point out that and I'm sure a staff member wrote this and that that the chairman, while reading it carefully, I'm sure missed this one point. But what the second whereas says is the special counsel Mueller's report found that the Russian government interfered and that President Trump used his official powers to thwart or attempt to thwart. The word thwart doesn't appear in the special counsel's report. The idea that the Mueller report found that President Trump tried to thwart or thwarted or attempted to thwart, it just does not is not consistent with that report. The truth is that the Mueller report did not make findings as to the 10 allegations. All I'm asking this committee to do is put in this whereas accurate legal language that is cited in the Mueller report so that the American public is not misled by this whereas. And I think it is only fair that this committee not impugn the integrity of the President of the United States until such time as it has evidence that it wants to charge the President with. This is false, and it should be clarified, and I would ask for the chairman to reconsider his opposition, and I hope that members on the other side of the aisle agree that we should have an accurate document. And I yield back to my friend from Arizona.
With that, I yield.
The gentleman yields. For what purpose does the gentleman from Pennsylvania seek recognition?
To strike the last word. To strike
The gentleman is recognized.
Thank you, Mr. Chairman. I support my colleague's amendment because it calls for clarification. Talking about clarification, I do have one question for my Democrat colleagues, and that is, are you conducting an investigation, an impeachment investigation or not? Because the resolution we are considering today does not authorize a formal impeachment inquiry, despite what the press might report today. It is nothing more than an inquiry into whether to start an inquiry. None of these provisions are unique to the impeachment proceedings. Anyone at any time can send a letter to the committee. Every committee in the House can allow for staff questioning. What we're doing today is meaningless. You already have this power as a committee. So which is it? Are you starting an impeachment investigation or not? Is this just more smoke and mirrors so you can appease the far left while doing absolutely nothing about this issue? Or is this so you can avoid talking about an agenda that includes banning airplanes, throwing Americans off their health insurance plans, eliminating our borders, maybe other parts of the platform like defunding ICE, giving illegal immigrants free health care, maybe banning oil and gas exploration. I mean, is that what this is about? Is this about distracting from the real platform of the party?
Would the gentleman yield?
No. Since November 2016, the Democratic Party has desperately tried to undo the will of the people. And I can tell you that in southwestern Pennsylvania, people want Congress to move on. They want us to work together. They want us to solve real issues that are facing America. They want their roads and bridges repaired. They want help fighting the opioid epidemic. And they want more money in their pockets to feed their families. So again, I ask, are you conducting an impeachment inquiry or not? If you are, just be honest with the American people. Be honest with your colleagues. If you aren't, then let's stop these political games and let's go to work for the American people. I've got a bipartisan bill on clean slate. Again, this bill is bipartisan. It would help millions of Americans get away from the stigma of having a nonviolent criminal record on their record. It would help them re-enter the workplace, increase their wages. This is bipartisan. We could actually do this. I'm friends with a lot of my colleagues. I've talked to them privately. We want to do something to help the American people, and we can start with criminal justice reform and a slew of other issues. But, Mr. Chairman, let's do something. Let's stop the political theater. Our country deserves better. With that, I yield.
Will the gentleman yield so he can answer his question?
No, I yield.
So the answer is yes. We are engaged in an impeachment investigation. And in addition to that, we have moved aggressively forward on the For the People agenda. It's about driving down health care costs, driving down the cost of prescription drugs, rebuilding the infrastructure of America, and taking on the corruption.
Regular order.
Regular order.
Gentleman was not recognized.
Gentleman from Pennsylvania has the time.
Thank you, Mr. Chairman. And I do thank and I mean this with sincerity, I thank my friend and colleague from Rhode Island. Thank you. And with that, I yield to my friend and colleague from Virginia.
Mr. Chairman, I also want to thank the gentleman from Rhode Island for admitting what we all know is happening. This committee is trying to have impeachment without actually putting a resolution before the people, before this House. I want to thank Mr. Buck for his amendment revealing what a farce this process is, this resolution which is, again, amateur hour when it comes to legal drafting. I have great respect for the chairman. I have great respect for members of this committee. They are accomplished attorneys. This committee should remember that words mean something, and what we are just revealing in this one amendment is just how these words are not legally accurate. We want this resolution, any product of this committee, to be legally accurate. Let's be better. Let's do better. Or do my colleagues on the other side actually recognize that, in fact, as I question the special counsel, his interpretation of the obstruction statutes was incorrect and is not a normal and reasoned understanding of our obstruction statutes. So if they want to vote to reject that this is, in fact, obstruction as alleged, let them go ahead. But I appreciate the gentleman from Rhode Island's admission that this is, in fact, an impeachment process.
The gentleman yield back?
I yield to Mr. Buck.
I thank the gentleman for yielding. I saw the gentleman from Rhode Island leave. I didn't know if you were putting time out because nobody on the Democrat side has voiced any answers to us, and I appreciate the gentleman's answer, and I yield back.
The gentleman yielded back. The gentlelady from Pennsylvania, for what purposes?
The gentlemen are, sorry, I moved to strike the last word.
Gentlelady's recognized.
The gentleman from Rhode Island got before me, but I too would answer, yes, we are in an impeachment investigation. Have you not been reading the proceedings? I don't think there's a question. It's an investigation.
Does the gentlelady yield back? The question occurs on the gentleman. For what purpose? The gentleman from Texas seek recognition.
Strike the last word.
Gentleman is recognized.
Thank you. Now that it's been publicly admitted that this is an impeachment investigation, and these amendments are even more critical because words do matter. And this would be litigated, and going back to my days as a Chief Justice, where we really had to dig on individual words. What does this word mean? And for whatever reason, the majority in this impeachment investigation chose to use twice the word thwart. And I could see this going up if this were a successful impeachment and removal from office. Clearly, it would go up to the highest court, and they would be stuck with the question of the president being a thwarter. They would have to deal with issues like, does thwarting involve moral turpitude? Because we've already heard it's not a crime to thwart that any of us are aware of. So, and the chairman had said, oh, it doesn't have to be a crime. Well, does thwarting involve moral turpitude? There are so many issues that would be raised on appeal by the misuse of proper legal terminology. This would be litigated for time immemorial, and it's just unfortunate. If you're going to try to remove a man for office for seeking justice and trying to stop himself from being framed by an unjust group within the Justice Department, then you really, this committee of all committees ought to use proper terminology and not create unnecessary litigation. I yield back.
Gentleman yields back. The question occurs on the amendment. All in favor of the amendment, say aye. Aye. Opposed, no. No. The amendment is not agreed to. Are there any further amendments? No further amendments? Then, a reporting quorum being present, the question is on the motion to agree to the resolution. All those in favor respond by saying aye. Aye. Opposed, no. No. In the opinion of the chair, the ayes have it. The resolution is agreed to. The roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Steen?
Aye.
Ms. Steen votes aye. Ms. Mucarsel Powell?
Aye.
Ms. Mucarsel Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins?
No.
Mr. Collins votes no. Mr. Sensenbrenner?
No.
Mr. Sensenbrenner votes no. Mr. Shabbat?
No.
Mr. Shabbat votes no. Mr. Gomert?
That's a no.
Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
Gentlelady from California.
Ms. Bass votes aye.
Gentlelady from Washington,
Ms. Jayapal votes aye.
are there any other members who wish to vote who haven't voted? The clerk will report.
Mr. Chairman, there are 24 ayes and 17 noes.
The ayes have it. The resolution is agreed to. This concludes our business for today. Thanks to all our members for attending. Without objection, the markup is adjourned.
Я хотел бы обратить внимание членов Совета на документ С-2019-682, доклад Генерального секретаря по миссии Организации Объединенных Наций по поддержке в Ливии. Совет готов приступить к голосованию по проекту резолюции, находящемуся на его рассмотрении. Сейчас я поставлю данный проект резолюции на голосование. Прошу
Will
голосующих
those
за
in
проект
favor of the
резолюции,
draft
содержащийся в
resolution
документе
contained in document S/2019/724
S-2019/724 поднять руку.
please raise their hand.
Результаты
The
голосования
result of the
следующие. За проект
voting is as
резолюции было
follows. The
подано
draft
15
resolution
голосов.
received 15 votes in
Проект
favor.
резолюции
The draft
принимается
resolution has been
единогласно в
adopted
качестве резолюции
unanimously as resolution 2486
2486/2019.
of 2019.
Заседание закрывается.
The meeting is adjourned.
The
8616th meeting of the Security Council is called to order. The provisional agenda for this meeting is identical letters dated 19th January 2016 from the permanent representative of Colombia to the United Nations addressed to the Secretary General and the President of the Security Council, document S/2016/53. The agenda is adopted. The Security Council will now begin its consideration of item 2 of the agenda. Members of the Council have before them document S/2019/725, the text of a draft resolution submitted by the United Kingdom of Great Britain and Northern Ireland. The Council is ready to proceed to the vote on the draft resolution before it. I shall put the draft resolution to the vote now. Will those in favor of the draft resolution contained in document S/2019/725 please raise their hand? The result of the voting is as follows. The draft resolution received 15 votes in favor. The draft resolution has been adopted unanimously as Resolution 2487/2019. The meeting is adjourned.
The
8617th meeting of the Security Council is called to order. The provisional agenda of this meeting is the situation in the Central African Republic. The agenda is adopted. In accordance with Rule 37 of the Council's Provisional Rules of Procedure, I invite the representative of the Central African Republic to participate in this meeting. It is so decided. The Security Council will now begin its consideration of item 2 of the agenda. Members of the Council have before them document S/2019/729, the text of a draft resolution submitted by France. The Council is ready to proceed to the vote on the draft resolution before it. I shall put the draft resolution to the vote now. Will those in favor of the draft resolution contained in document S/2019/729 please raise their hand? The result of the voting is follows. The draft resolution received 15 votes in favor. The draft resolution has been adopted unanimously as Resolution 2488 of 2019. I will now give the floor to members of the Council who wish to make a statement after the vote. I give the floor to the distinguished representative of France.
Merci, Monsieur le Président.
Thank you very much, Mr.
Je souhaite tout d'abord souhaiter également la bienvenue à l'ambassadrice des États-Unis et l'assurer de notre plein soutien à sa mission. La France salue l'adoption à l'unanimité de la résolution 2488 qui autorise un assouplissement de l'embargo sur les armes sur la République centrafricaine. Je souhaiterais remercier l'ensemble des membres du Conseil de sécurité pour leur engagement constructif dans ces négociations. Monsieur le Président, je souhaiterais revenir sur 2 points concernant cette résolution. Le Conseil de sécurité respecte les engagements qu'il avait pris avec la résolution 2454 adoptée au mois de janvier dernier et répond à l'appel exprimé par les autorités centrafricaines concernant l'embargo sur les armes. C'est sur la base des progrès réalisés par les autorités centrafricaines que le Conseil de sécurité a décidé de s'engager sur la voie d'un assouplissement de l'embargo sur les armes. Cette décision est le reflet équilibré des positions des États membres de ce Conseil. En allégeant de manière significative la procédure d'exemption pour les armes, le Conseil apporte donc une réponse forte à l'appel des autorités centrafricaines, réitéré il y a quelques jours encore. La résolution que nous venons d'adopter permettra en effet de faciliter le rééquipement des forces de défense et de sécurité afin que ces dernières puissent contribuer à la sécurité de leur pays et de l'ensemble des citoyens centrafricains. Monsieur le Président, je souhaiterais ensuite souligner, et ce sera là mon second point, que l'adoption de cette résolution est également un encouragement pour les autorités centrafricaines à poursuivre la dynamique engagée depuis plusieurs mois et à continuer de progresser sur la mise en œuvre des 5 critères définis par notre Conseil. Cette résolution comporte un certain nombre d'éléments permettant au Conseil de sécurité de continuer à suivre la mise en œuvre de cet assouplissement de l'embargo sur les armes. Avant de conclure, je souhaiterais souligner que le retour d'une paix durable en Centrafrique passe aussi par la lutte contre les trafics transfrontaliers d'armes et de munitions qui continuent d'alimenter les groupes armés. Dans ce contexte, nous appelons les pays de la région à s'engager avec la République centrafricaine pour lutter contre ces trafics. Je souhaiterais enfin rappeler que dans le cas de la Centrafrique, les sanctions n'ont jamais été conçues comme une fin en soi, mais toujours comme un moyen pour contribuer à notre objectif commun, celui de la stabilisation et du retour d'une paix durable en Centrafrique. Je vous remercie.
Я благодарю уважаемого представителя Франции и предоставляю слово уважаемому представителю Côte-d'Ivoire. Merci, Monsieur le Président. Je voudrais, à mon tour, souhaiter la bienvenue à Mme Kelly Craft, notre collègue des États-Unis,
Kelly Knight Craft, our colleague from the United States,
assurer du soutien de ma délégation
and ensure her that she will have the full support of my delegation in ensuring the success of her mandate.
Je prends la parole
I am taking
au nom
the floor on behalf
A3, donc
of the
les 3 pays
A3, the 3 countries,
africains membres du
3 African countries that are non-permanent members of the Security Council, Equatorial Guinea, South Africa and Côte d'Ivoire.
Les 3 pays membres
The 3
A3
member countries of the A3
se félicitent de l'adoption
welcome the
de la
unanimous
résolution
adoption of Resolution
qui
2488,
assouplit l'embargo sur les
which
armes
makes
imposé
more
au
flexible the
gouvernement
arms
de la République
embargo imposed on the Central African Republic.
Nous félicitons le porte-plume de s'être engagé à veiller à ce que les
Congratulate
engagements
the
du Conseil de
penholder
sécurité
in ensuring
vis-à-vis du gouvernement
that
de la
the
République
engagement
centrafricaine
of the members of the Security
soit
Council
respecté
and
en ce qui concerne
ensuring that
l'assouplissement de la mesure d'embargo sur les armes
relations
à
with
l'aune des progrès
them are
accomplis.
respected in lightening the
Indéniablement,
sanctions regime.
l'assouplissement de la
Undeniably,
mesure d'embargo sur les armes en faveur du
lifting
gouvernement
of some of
centrafricain
the arms embargoes against
constitue
the
un
Central African
puissant
Republic
moteur
government
des
is a
efforts
powerful driver of the
multidimensionnels
multidimensional
visant à accélérer
efforts
le
aimed at
rétablissement de
speeding up
l'autorité de l'État
the re-establishment of the state's authorities across the national territory.
Un tel développement positif
Such a positive development
permettra au gouvernement
will
de la
allow
République
the government of the
centrafricaine
Central African
de
Republic
s'acquitter efficacement de son obligation de protéger son peuple
protect
et de défendre
its
son
people
intégrité
and
territoriale
defend its territorial
depuis trop
integrity,
longtemps mise à mal
which for so
par une
long has
recrudescence
been jeopardized
attaques
by
des
the
groupes armés.
increasing level of attacks
Mr.
from armed
President,
groups.
The fact that Security Council adopted this resolution is indicative of our government's continuous commitment towards the implementation of the sanctions regime, in spite of the challenges it faces in implementing the political agreement. It should be noted that if they are strictly respected, the sanctions constitute an effective instrument that can accompany the action of the Central African authorities, notably in the implementation of the political agreement for peace and reconciliation in CAR signed on February 6, 2019, between the government and the armed groups. Our 3 delegations joined consensus on the sanctions mandate renewal because of a realization that